right, this is case number 22-192-401. This is Estella Huff, Marathon Insurance Company. Today is a time set for a pretrial conference in this matter. The court previously set up a scheduling order regarding this matter. Your appearance for the plaintiff in this matter, please. Counsel for Estella Huff. Do I have counsel for Progressive?
Yes, Your Honor. Yes, Your Honor. I'm sorry. Rachel Schwartz on behalf of the plaintiff, Estella Huff.
All right, thank you, Madam Counsel. Your P number, if you will, for the record.
P54947.
Thank you, counsel for defendant in this matter.
Good morning, Your Honor. Bradley Wing on behalf of defendant Progressive. My P number is 69812.
Thank you, Mr. Wayne, and good morning to you as well, sir. So I know you've had some time for discovery regarding this matter. I have a note here that the plaintiff may have been requiring a guardian, that there was some action in probate court regarding this matter. Somebody update me regarding this, Ms. Schwartz.
Your Honor, unfortunately, I just inherited this file. Connor from our office left. I do see there's some notes about that. I don't believe any action is taken yet. Although upon my review of the file, I do think that this may exceed your jurisdictional limits. So that's where we're at right now.
Thank you, Mr. Wing. You care to weigh in at this point, sir?
Sure, Your Honor. We have scheduled the deposition of the plaintiff, and I have agreed to hold off on it to allow plaintiff attorney to seek that guardian. And if it is over the jurisdictional limits, I will agree to remove it to the circuit court. I have no issue with that. Just kind of wait to see how the plaintiff wants to go forward with the guardian issue.
Yeah,
Right.
Your Honor, it appears that there could be a lien from Aetna in the amount of like $23,000. I don't have that yet. I know they paid that much. I assume they're going to be asserting that lien, and that would take it over the jurisdictional limits.
Yeah, I guess the issue here is whether we should drill down on what seems to be a predicate, and that is in relationship to Ms. Huff and the need for a guardian. My inclination, of course, is that if the numbers are putting it in circuit court, then I would sign an order transferring it over, or the two of you could stipulate to the same. Again, if there is one claim that is at 23, and then you got this case that what was your claim here? Let's see what the numbers were. I don't see a specific number. Somebody tell me what I'm missing here. Yeah, well, it said 10,000. So yeah, that was $30,000. So unless there is an objection, it seems to me that neither party is disputing that there is at least a claim that is over that's over $25,000. I'll sign an order transfer the jurisdiction.
Okay, I'll send an order to defense counsel for signature and submit it to the court. And then in the interim, that will give me a little bit of time to assess the need for a guardian.
Mr. Wayne?
No objection there, Your Honor. If she's going to make that claim, I'm happy to accept that. All
right, very well. Madam Counsel, let me give you the email address where you want to send that order as soon as you got your hands on it. And I'm hoping that that's within the next 7 to 10 days. So you want to send it to Carmen, CARMEN, last name is Banks, BANKS, at 336th 36 District Court.org.
And it's 36 District Court. So the numerals 3 and 6, and then District Court.
36th 36th District Court.org.
Okay, thank you.
All right, counsel, I'll wait your word. Thank you, Mr. Wayne. Good morning to the two of you.
Thank you, Your Honor. Good morning as well.
The court now calls case number 22-19-8971. This is Bonneview Apartments LLC versus Jasmine Harshaw. The matter is before the court, set on for a status scheduling conference. The court is in receipt of defendant's answer to the complaint. Matters been joined accordingly. Your appearance for Bonneview Apartments, please.
Good morning, Your Honor. Aaron Cox, P69346, appearing on behalf of the plaintiff.
Thank you, and good morning to you, Mr. Cox. I'm looking now for Jasmine Harshaw. Say something of you here at this time.
Good morning, Your Honor. This is Jasmine Harshaw.
All right, thank you, Ms. Harshaw, and good morning to you as well, ma'am. Counsel, update me on where this is. It looks like there is a claim that has been asserted in this matter alleging outstanding damages of $7,800. Has there been some discussions or any effort to try and get this resolved, counsel?
Not yet, Your Honor, and if the court has time this morning, I wouldn't mind going into a breakout room with Ms. Harshaw to see if we can figure something out.
No, Your Honor, no one, I have proof that I never did any kind of damage in that apartment.
Okay, but so you don't want to talk about any possibility of resolving it, correct?
We can, but I would not settle for anything. That I'd rather go to court, but we can talk about it.
You are in court, and
Okay.
In court, one of the things that happens is that people talk about it to see what their positions are, and then if they can't resolve what their positions are, then the court sets up a scheduling order on the case, and then ultimately the case ends up either being decided by a motion or by a trial. So there are a number of ways it can be ended. When you say you don't want to talk, if you don't want to talk, I don't care one way or the other, but that's usually the starting place that most people, at least on the
will he be able to prove to me, show me what he's talking about? Because I have proof that I didn't.
You certainly didn't interrupt me. I know you did.
I apologize. I definitely do apologize.
I'm just going to assume that you didn't do that, because we don't do that here. Okay. So I'm going to give you a moment to talk in the breakout room. Nobody can, of course, force you to do anything. This is just talking about it, finding out where their position is, you telling them what your position is. If you don't want to do that, then just say you don't want to do that, and I'll set it up another way. That makes sense to do that. That's not. I think you're grown and mature enough to know that that any decision made about this case in terms of resolving it would have to be a decision made by you and the other side. If you don't want to talk about it, you just don't want to talk about it. I don't have a problem with that either. But as a part of this, of course, when the court is talking, you can't interrupt that part, but we'll always let you have a chance to say what you want to say. That will always be. All right. I take a moment to say that because I know Mr. Cox may come to court on a regular basis because he's a lawyer and you don't. But when you come here, at least when you come in front of Judge Coleman, you always get a chance to talk. Just don't interrupt when the court is talking, because I'm the official that the state has that runs this. So when I'm talking, you don't say anything, but then I will always give you a chance to say something. All right. So I'm sending you a notification now, along with Mr. Cox, to go into the breakout room and see if you can talk about it, see if there are any possibilities of resolution. If not, then both of you will click back in and then we'll make a decision what to do with the case next. All right. All right. I wish you well. I'll talk to you.
Thank you, Your Honor.
All right. The court now calls case number 22196501. This is Credit Corporation Solutions Incorporated versus Rachel Orange. The matter is before the court, set on for a scheduling and status conference. This is the first time that this case is up in front of me. Your appearance for Credit Corp in this matter, please.
Judge, may I please court? I'm Attorney Richard Gruesome. I run with 35222. I'm the attorney of record for the plaintiff. I'm also the attorney of record for the plaintiff in today's pretrial.
Thank you. Good morning to you, sir. I'm looking now for Rachel Orange or counsel for Miss Orange. If you're on the Zoom, please say something at this time. All right. So, counsel, have you spoken with the other side? Looks like attorney.
Judge. Thank you, Judge. I have not spoken to defendant attorney. I was actually out of town last week at a legal conference. I basically would ask the court for a default today to enter, and then maybe we can get some movement from opposing counsel after that.
All right. Not real fond of, as you know, entering defaults where there's an attorney on the other side. You have.
That's quite all right. Quite all right. Then what I would do, Judge, is for lack of a better word, ask that a standard scheduling order be entered. I would ask for 2 weeks. I would ask for 60 days discovery because I have about 42 statements, including actual credit card use and payments. I'll be delighted to send that to opposing counsel for review, and then we can see where we stand after that.
Yeah, either that way, Mr. Rosen, you were all over me then too. You have to shut up when I'm talking. So, let me say to you that one other option, sir, is for me to set it out a couple of weeks and try and get it back here and see if they want to show up.
That'd be fine. I'll let you be the judge of that.
Thank you for your permission on a Monday morning. All right. Mr. Rosen, I'm gonna set it over for a couple of weeks and see if they'll at least come in, although I think your approach is meaningful as well. But let's keep it and stretch it out. And so I'm gonna bring this back. Just 1 second here, sir. All right, yeah, I'm gonna bring this back on the 27th. The 27th of February.
Okay, so
I'll set it at 9:30 and we'll send out news.
So just so I understand, then we're going to continue the hearing to February 27th, 2023 at 9:30 a.m.
That's correct, sir.
Thank you, Judge.
Thank you. Good day.
Bye.
All right, the court now calls case number 22-189-373. This is Alawa, Muhammad Alawa versus Marzouk Abi. The matter is before the court. Set on for a motion for entry of default, it looks like. I require that an answer be filed relative to that motion by the 13th, by today's date. Let's see where we are with this. All right, your appearance, plaintiff. For the plaintiff regarding this matter. All right, I see Mr. Awali.
Yes.
All right, good morning, sir. Say your name for the record.
Muhammad Alawiya.
All right, thank you, Mr. Alawi. Good morning to you. Do I
Good
have
morning.
Marzouk Abi? Are you on the Zoom? All right, Mr. Alawi, when did you have you spoken recently with Mr. Abi?
No.
Let's see what's going on here. 1 second, sir. All right, I see that Mr. Gasdecki is the attorney for the defendant in this matter, and he has a motion pending in front of me. And let's see what I require here. So that you file an answer to the counterclaim, sir?
Yes, my lawyer, he answered. He sent to the court.
All right, who is your lawyer? Has he filed an appearance? I don't see an appearance for your lawyer. Do you have a lawyer?
Now, Hussam, hold on, Judge. Let me just see exactly what's his name. But
Did he know about today's court date, your lawyer?
yeah, he sent me. He's supposed to be. I don't know why he not be in the court, but his name is Haysam El Qudesi.
Okay, you're saying his name, correct?
Yeah,
Okay.
Hayyssam.
I do see that he's filed a notice of appearance and that he did file an answer and affirmative defenses. I'm concerned because he needs to be here and the attorney for the other side needs to be here as well. So I'm going to wait a few more minutes and then I'll come back to this case and we'll figure out what we do in just a few moments. So you just hold tight because the other side, they should be here, but we'll figure out what's going on shortly.
Okay, thank you, Judge.
Thank you. All right, the court now calls case number 22-190-374. This is Progressive Marathon Insurance versus Kanisha Dunner. The matter is before the court, set on for a pretrial conference. The court issued a previous scheduling order regarding this matter. For Progressive, please.
Good morning, Your Honor. Tiffany Williams on behalf of Progressive, P number 74809 for the record.
Thank you, Ms. Williams, and good morning to you, counsel. I'm looking for Kanisha Gunner. I believe I see her there. Good morning to you, Ms. Gunner.
Good morning, how are you?
I am good this morning. All right, Madam Counsel, if you will, update me on the status of things. I know I allowed some discovery already.
Yes, so we sent discovery to Ms. Gunter. She has said she's answered it, so we're just waiting to get her answers back to the discovery. We actually this morning, she didn't send formal discovery, but we sent her a copy of the pictures of the damages and estimates. And I let her know that if she needed anything else, she didn't have to formally request it. She could just email me whatever additional documents she may need. We are at a position where liability and damages are still at issue. So I suggested to Ms. Gunter, maybe it would be possible if the court is inclined to allow us to do mediation. Maybe that'll kind of bridge the gap a little bit. And it looks like she was in agreement.
That sounds like a reasonable approach. Ms. Gunner, anything you wanted to bring to my attention at this time, ma'am?
No, sir.
All right, so what I'm going to do, Madam Counsel, is the case ready for mediation now, or sending it to some type of mediation?
Your Honor, I would request for it to be sent to mediation, but to keep discovery open, because I did indicate to Ms. Gunter if she thought of something else she wanted to ask us for, she could. The photos I sent was just really specifically of the damage. It's not all of the photos we have, so I don't know, she may want all of the photos. And I didn't send her proof of payments because we were talking more about damages. So she may think of other things she wants. So if the court could just leave the discovery open.
She will keep. Ms. Gunner, were you saying anything, ma'am?
I don't think she's on mute.
All right.
I muted it, I'm sorry.
Oh, yeah, I saw you unmuted, and I was wondering if you were saying anything. Were you trying to say anything?
No, sir, I was listening.
All right, very well. So I am going to, I will allow the discovery order to continue, allowing the parties to exchange information. And I'm going to set a control date in this matter, and that date is going to be the 4th of April. I'm going to sign an order allowing for a mediated process, and then I'll set a review date on 4/4/23. You'll get a notice regarding that date at 9:45 a.m. 4/4/23, 9:45 a.m. And you'll get an order from me regarding mediation and continuation of discovery. You'll get that order in the next couple of days.
Thank you, Your Honor.
Thank you. All the best.
Thank you, Ms. Gunner.
Thank you.
Thank you.
All right, we're back on the record regarding the suffix 8971. Thank you, Mr. Cox, Ms. Hartshaw. They have gone into the breakout room to discuss the broad parameters of this case. Mr. Cox, I see that you're back. Ms. Hartshaw, I see that you're back. Mr. Cox, update me, sir.
Your Honor, I've spoken with Ms. Harshaw, who's informed me that that is her maiden name. So we probably have to amend the caption to reflect her married name as Braggs. Other than that, Judge, we were unable to reach a resolution. We'd ask the court to just provide a scheduling order for us.
All right, very well. I will set the matter up on a pretrial scheduling order, which I will generate and send, and you get it in the mail in the next couple of days. That scheduling order will allow for discovery during the next 60 days. Discovery will be allowed through, just one moment. Yeah, that's going to be through the 17th of April. That's 4/17/22. 4/17/22. The parties will 23. The parties will be ordered to come back to court on that date at 9:30 a.m. My discovery order will allow for the exchange of information between the parties formally during that period of time. Discovery will be cut off at the end of day on the 17th of April. The discovery order also has a paragraph number 6 that allows for the filing of motions. Either party may file a motion either to bring the case to an end or for some other reason within the case, and have it set for hearing on that same date, that is the 17th of April. The only requirement is that you allow the party opposing your motion at least 10 days to respond to the order. So if you file a motion, summary disposition, or any other kind of motion that you want to file, I'm shortening the rules, so you file it, and you give the other side at least 10 days to respond. I will hear that motion on the 17th of April. So you could set it for hearing on the 17th because that's the date I'll hear it, as long as you've given the other party at least 10 days to respond. All right. Now that is not a rule that cuts off a filing of a motion at a later point in the future. It's just that if the issues become clear enough to file a motion in time for that date, then I'll hear it on that day. All right. So you'll get a formal order from me in the mail in the next few days, and I do wish both sides well all the best.
Thank you, Your Honor.
The court now calls case 22-182-559. This is Garner Properties versus Michael Gamble Jr. The matter is before the court set on for a pretrial conference on today's date. The court did note the filing of a motion for summary disposition in this matter. It looks like that motion was filed in December. The last hearing in this matter was in December. Your appearance at this time for the plaintiff counsel.
Good morning, Your Honor. Aaron Cox, P69346, excuse me, appearing on behalf of the plaintiff.
All right, thank you. And Mr. Gamble, Michael Gamble, you present, sir?
Yes, I am. Good morning.
All right, good morning to you, sir. All right, Mr. Cox, go ahead and update me where things are regarding this matter, sir.
Judge, I don't have much of an update for you, if any. I haven't spoken with Mr. Gamble at all. We have not received a response to our motion for summary disposition. If you have time, Judge, I'd be happy to talk to Mr. Gamble before we hear the motion to see if we can reach a resolution.
Yeah, I do see the motion, man. Mr. Gamble, you didn't file anything in writing regarding this motion, correct?
I turned in the documents I had to prove that I communicated with Gardner Properties about leaving.
So you didn't answer my question though, right? My question is, you got this motion for summary disposition. You didn't file any response to that written document, correct?
Correct.
All right, but you did file your answer. That's what you were talking about. And you were pointing out to me in your answer, you denied the obligation, correct, sir?
Yes.
So I'm gonna ask that you go and take a moment in the breakout room to see if you can talk about getting this resolved before I make a decision on what the motion is. Because without there being a written response to the motion, that's a significant setback in this regard. Maybe you can get it resolved before we take a look at that. So let me send you a notification and at least try to talk about this and see if you can get anywhere with that.
Okay.
There's your notification. Mr. Cox, I'm moving you to breakout 2.
Thank you, Judge.
And I haven't forgot about you, Mr. Alawali. I'm coming back to you, sir. All right, this is case number 21-153-543. This is Integrated MRI Center LLC versus City of Detroit. Matters for
Give me.
looks like on the filing of a one moment here.
The lawyer,
Yeah, just stand by, sir. I'm coming back to you in a moment, sir.
okay, thank you.
Do I have anyone on Integrated versus City of Detroit? I have a motion to dismiss here. I have plaintiff's response to the motion. on this matter. All right, I'll come back to that matter. Do I have parties on? It's the same case.
Okay.
Okay, Mr. Alawi.
Yes.
Yeah, it looks like neither your attorney or the other attorney has appeared in court today. So I think the only thing that I can do is to set up another date for them to be here. You're the only one that showed up.
Can you give me just a couple minutes, 2 minutes to the lawyer, my lawyer, he can connect to the court right now. He have some issue, he can be right now after couple minutes. If you can give me a couple minutes, please.
I will, and the likelihood is with the other side attorney not being here, that it would still end up being adjourned. So I'm gonna set a new date on this. But if you think you can get your attorney here, I'll certainly give him an opportunity to say something.
Okay, he's coming now, sir. Give me a couple minutes, please.
All right, thank you. Counsel, good morning to you, sir. Regarding regarding the suffix 259, strike that 255. Actually, the suffix 3, strike that the suffix 9373. Alawi versus Obed. Your appearance, counsel.
Hello?
Go ahead. Yeah. Your appearance, please.
Oh, actually, I'm just contacting you from Akachi Law Firm. I'm the paralegal. I just wanted to let you know the attorney, for some reason, isn't answering the phone, and he has a court date today for Alloway versus Alloway Construction versus Marzouk Awade, and he is not answering. I'm actually a little bit worried about him. I'm gonna go check up on him right now. But he hasn't been answering the phone to me this whole morning, so he never does this, but I don't know what's going on. So I just want to let you know if we can get this adjourned or something, just so I can figure it out.
Yeah, what's your name again?
My name is Hussein.
Yeah, you gotta give your full name in court, sir.
Oh, sorry, Hussein Al Muhammad.
And you work for Mr. Hassan's office, is that what you're saying, sir?
Correct.
All right, so the other attorney on this matter has not appeared in court today as well. That's unusual for Mr. Gazdecki. So I'm going to go ahead and adjourn it and give it a new date so that the attorneys can get here. So I'll go ahead and set it for March 7th.
March 7th.
Yeah, and they'll get notices in the mail, March 7th, 2023, and that's going to be at 9:30 a.m.
Hold on one second.
9:30 a.m. Thank you so much, Your Honor. I appreciate it.
All right, thank you. Good day.
Thank you. I will let the other attorney know too. Thank you.
Hold on one second.
There's an attorney that just called who was in the waiting room. I think he was in the wrong court.
Who is that?
He didn't say. I told him to zoom in. I told him the correct court.
All right, there is one attorney that's in a waiting room in another courtroom, so let's hold on one second. That's Mr. Gazdecki. Okay. All right, so just one moment. Stand by, everybody. Good morning to you, Mr. Gazdecki.
Good morning, Your Honor. I was in the wrong courtroom.
Right, that's something that has become apparent to us, and I understand how that happens. Your appearance regarding the defendant in this matter, sir.
Yes, Your Honor. Good morning. My client's trying to get, hold on. Hello?
Courtroom are you?
Okay, 336. It doesn't say a judge. You just go to 336 on down the list. It's in the, it's in the other, it's in another category. Bye. Sorry about that, Your Honor.
All right, not a problem, sir.
We're,
Go
we're,
ahead.
we're playing find the courtroom.
Yeah,
Court,
that's,
are you in?
that's gonna end up real soon. I'll explain some of that in a moment. Go ahead and enter your appearance for, the defendant, counter plaintiff in this matter, sir.
Good morning, Your Honor. Mark Estecchi, P46289 on behalf of the defendant counter plaintiff.
Thank you, counsel. And Mr.
Duke Obey.
Thank you, sir. Mr. Awali is here, and someone from Mr. Hassan's office. I'm sure that you got the appearance of counsel for the plaintiff, counsel.
I did.
All right, and he has not appeared here. His office indicates that they've been reaching out to him, and he hasn't returned phone calls, and so they're concerned. They've asked that I adjourn the matter when I thought that you were not here either, and I mentioned that that was unusual, and that was even more reason to adjourn it. I think that the
So who hasn't showed up?
counsel for Mr. Alawi.
Huh. That's who I thought I'm seeing right now.
No, that's someone from his office.
Oh, okay.
Yeah. He's a paralegal.
Oh, he's a paralegal. Oh, hi, sir.
Hey, how are you?
All right.
Future attorney.
Future attorney. Well, no, become a pharmacist. You get good hours and great pay.
Right.
Well,
Your Honor, I guess, I mean,
I was sending it.
I would like to do a scheduling order if we could.
Well, I'm okay with doing that as well. The issue that was kind of stopping everything was I think the motion for entry of default on the counterclaim. And
You voted against that already, Your Honor.
did I?
Yes,
I
you
thought I
did.
said- No. Okay, well, you're all right.
I made a record of it. I wanted it defaulted.
Obviously, you have fewer cases than I have. It's typical that I would do an order in that regard. Oh, I did issue an order. All right, very well. So I will now. It looks like counsel has made it in as well. Counsel for Mr. Mohammed Alawi.
Yes, Your Honor, I'm extremely sorry. I have a terrible experience with my alarm today. I just wake up, to be honest. It's unbelievable.
Well, we were just telling your paralegal to become a pharmacist. Perhaps he could get you woke a little easier. But
He did great. I have a terrible experience just last night, Your Honor, with sleeping.
I'm glad you're better. I wish that the worst experience you had yesterday was that your team lost, but
What a great game.
it was a great game. All right, your appearance at this time, counsel for the plaintiff in this matter, sir.
Yes, good morning, Your Honor. Haysab Qudsi on behalf of the plaintiff, Your Honor. We did file our appearance, Your Honor, on January 27.
I have received your notice of appearance, sir. Your P number, if you will, for the record, sir.
68565.
All right, thank you, counsel. Mr. Gazek is here as well, and he has asked that the court will go ahead and set a scheduling order regarding this matter. That makes sense to you, sir?
Yes, please.
All right, very well. So that's what I'm going to do, and I will go ahead and set this up for the next action date, not the 7th of March. That was going to be an adjourn date. We're going to set this for 4/17/23 at 9:45 a.m. 4/17/23. Discovery will be open through that date. I will issue an order regarding this case going forward, and that order will have that date as the next date for you to come to court as well. So discovery is through the 17th of April, but that's the next court date as well. And you'll receive a copy of my order in the mail in the next few days.
Your Honor,
Yes, sir.
Thank you, Your
would
Honor.
you entertain the idea that if we need more time for discovery, it'll go past April 17th?
Absolutely. April 17 is an intersecting day where discovery comes to an end, unless the parties tell me something that lets me know that it needs some more time. So,
Because
as
I
long
was
as you-
also going to suggest that we schedule possibly after the discovery possible mediation date and case eval date.
And that's what happens on the 17th of April. The 17th of April, I find that my order has worked so effectively that the parties have been able to resolve matters, or I find out that I need to make adjustments. And reasonable adjustments are made. There's not a court rule, but my rule is reasonable adjustments are made where justice so requires. So in other words, you come on the 17th and you've been moving forward, and it appears that you need more time, or that you're ready for a mediated type of approach. Then the court will integrate that into an order, and then we'll go forward.
Okay, thank you, Your Honor. Now, on that date, at 9:45, I might be running into Judge Millhouse's. I'm in Judge Millhouse at 8:35.
Not a problem. All you need to do is give some notification to my courtroom, and you should be okay. The other thing that among the attorneys is when you are, if you're coming back on this, and you're running a little bit late, then the other side, just let them know. And when you come in, I love that collegiality that says, counsel told me he's running a little late. So, okay.
Thank you, Your Honor.
All right. So see you on the 17th. And again, that's the close of discovery. But if there are other things needed, then the court will address that at that time. All right. Paragraph.
Thank you, Your Honor.
Thank you, Your Honor.
Paragraph number 6 is an important part of the order because it allows you to file motions and have them heard on the 17th as well. And you'll see how that order is styled. That does not cut off the filing of motions in the future. If something comes up that you want to bring to the court's attention, you don't have to go searching for a date for hearing. Set it for hearing on the same day. Motion. Set it for hearing on the same day as the pretrial, and I will hear it on that day. One requirement is that you give at least 10 days notice to the opposing party. So you file something, file it early enough for the other party to have 10 days to respond, and I will hear it on the 17th.
Thank you, Your Honor.
Thank you, gentlemen.
Thank you, Your Honor. Thank you very much.
الساعة 9:45 شهر 4.
Marzouk, please leave the meeting now.
Okay, thank you.
All right, good day. Good day, Mr. Olawale. All right, and welcome back, Mr. Cox, and let's see, and Mr. Gamble. All right, just one moment. All right, we're back on the record regarding the suffix 2559. All right, thank you, and welcome back, Mr. Gamble. Welcome back, Mr. Cox. Mr. Cox, update me, sir.
Your Honor, I had an opportunity to speak with Mr. Gamble in a breakout room. Unfortunately, we were unable to reach a resolution. So at this time, Judge, we are going to ask the court to hear and decide on our motion for summary disposition.
Thank you, counsel. You may proceed. You may proceed at this time on the motion, sir.
Thank you, Your Honor. Judge, this is plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. The defendant has not stated the defense of the cause of action, and there is no genuine issue of material fact that the defendant is liable to the plaintiff and the amounts paid for. Your Honor, this matter arises out of a landlord-tenant relationship in which Mr. Gamble signed a lease agreement. That lease agreement obligated him to pay rent and to return the property in the same condition upon which it was delivered to him. Mr. Gamble failed to do so. We've attached to our motion a copy of the lease agreement as well as a copy of the ledger identifying those charges in which he did not pay. Mr. Gamble has not filed a response to the motion, and as this court is aware, MCR 2.116G4 requires him to do so and directs this court that in the event he failed to do so, and we've otherwise met our burden to establish the prima facie case, the court is compelled to enter the judgment that's been requested at this time. As Mr. Gamble has not filed that response, and as there is no genuine issue of material fact on record before this court, we are asking the court to enter our grant our motion and enter judgment accordingly against Mr. Gamble in the amount of $5,145.06. Judge, I will just add, I spoke in speaking with Mr. Gamble in the breakout room. I don't really think there is a substantive dispute here at all. He identified that he left the property early, but notified my client, he very well may have, but the lease term had not yet expired. So his rental obligation continued, notwithstanding him maybe providing my client with the notice that he in fact had vacated. So there being no dispute, Your Honor, we'd ask the court to grant the motion.
All right, just one moment, Counsel. And I've looked at the answer to the complaint, and the answer to the complaint does deny the claim. It's a general denial with no specifications. Is that your understanding, Counsel?
Judge, I do not have a copy of the answer in my file, but I will take the court at its word that that's what it says, and I would agree, Judge. And Judge, I'll just add for the record, as I think the court is aware, in a C10 motion, right, the mere allegations and denials and conclusions without factual support are insufficient to overcome the burden.
Yeah, I mean that's why I went to the answer to see if there was some specification set forth in the answer that may provide something of a predicate that may militate against the nature of the motion. What I'm looking at is the answer that provides a response to items 1 through 7. Item 1 is do not know if the statement in paragraph is true. Item 2, agree with the statement in paragraph 2. Item 3, agree with the statement in paragraph 3. Item 4, do not know if the statement in paragraph 4 is true. Statements are true. Do not know on paragraph number 5 if the statements are true. Number 6, I agree with the statement in number 6. And then number 7, do not know if the statements in paragraph number 7 are true. That is the extent of the answer that's been filed. I thought maybe you had saw that, and I wanted to confirm whether or not you had received anything other than that in this case before I go to Mr.
Judge, I have not received any other document, and in hearing the court's recitation of the answer, I would just point out that his do not know responses with respect to paragraph 5 and 7 were simply related to the specific dollar amounts that are being claimed. But maybe more importantly for the court's determination in paragraph 6, the allegation in the complaint is defendant's conduct as set forth herein constitutes a breach of the contract between the parties. And you indicated his response to that was admitted. I think that's telling with respect to the determination on the motion here.
All right, Mr. Gamble. Tell me what you wish to say. It looks like you in your answer you didn't even dispute this.
I just want to apologize for that. I'm not really too recognizable with the way the court system works. The filing the motion part, I wasn't aware of. I had came down to 36th district, and they pretty much stressed the whole part about me turning in some information for the discovery packet for both parties to look at. And it's still up there with the gas. That was my main reason for leaving so soon. They found gas leaks. the maintenance people, they never came out. And I was just put in a place where I had to take my kids to a safer environment.
Why did you put that in the answer that you got? Why you write that in your answer? You never, in your answer, you answered paragraph 1 through 7. When you came to paragraph number 6, you said you didn't disagree with that. You indicated that you weren't sure about what the damage amounts were. And then when the motion is filed, you didn't put anything in writing regarding that. I'm just concerned. It doesn't. Well, tell me anything else that you think I need to consider at this time. So, Mike.
As I was telling Mr. Cox, I brought a lot of value to that home, I believe. When I first moved in, I sent out everything that I complained about, and nothing really happened other than the window. They did come out and fix the window, but when it comes to like the electrical, I had a 220 wire, live wire, that was in the ground that had been dug up. My daughter, she slipped in there, almost got electrocuted. So I had to get my own electrician out to fix that 220 wire that goes out to the garage. So I got that fixed. I got some plugs in the house fixed that didn't work because the maintenance people never came out. I complained about the driveway being repaved. That never happened. And then it came to the point to where I was ready to move from the property. And that's when the gas leak happened. That's the pictures that I had sent in with the DTE paper saying what happened. And I sent out emails trying to get them to come out before I even broke the lease. I was trying to communicate with them. And I know it was the COVID time and our office was closed. So it was nothing I could do. I had no other option but to leave.
All right, anything else you wanted to tell me at this time, sir, Mr. Gamble?
No.
I don't have anything to add, Your Honor.
Yeah, listen, the standard regarding the court's evaluation of this matter is whether or not there has been affidavits or any written documents to contest the motion for summary disposition that will raise a question of fact. And in this situation where in the complaint on the paragraph 6, defendant does not dispute the breach of contract, he seems to argue in an oral argument that the breach of contract was secondary to some problems that existed on the premises. That was never raised, and the extent to which it would have been raised under this scenario does not seem to give rise to a defense to the claim of breach of contract in this matter. But more specifically, the defendant has not pled a defense under MCR 2116 C9, and certainly there is not any factual development that has been set forth in affidavits or any documents that could have been submitted in response to the motion for summary disposition as required by law to contest the issue documents that control this relationship. The primary document that controls the relationship is the rental agreement that existed between the parties. That agreement shows that there was a continuing contractual relationship that existed between the parties at the time that the defendant exited the premises, and that exit from the premises was not with any written permission that would allow him to avoid the consequences of the contract. Accordingly, the defendant remained under contract for a time, even though he exited the problem. I don't find what I do find is that the plaintiff in this matter has met the burden required under the court rules, MCR 2.116C9, in this matter. And the defendant is bound to provide any evidence or information that was would show that there is anything but a breach of contract in this matter. There is no real factual question to be resolved by the court. Defendant is entitled to strike that plaintiff is entitled to judgment as a matter of law in this matter. There being no sufficient defense raised to this. For that reason, the court will grant the motion for summary disposition, allowing for the entry of judgment based upon the motion at this time. The court finding that there is no genuine issue of material fact, defendant is entitled to judgment as a matter of law, and further, that there has been no valid defense raised to this matter. And without a valid defense, the plaintiff would be entitled to judgment in this matter. It is so ordered. I do wish you well. You receive a copy of the court's order once it's been signed, and that order will indicate that the plaintiff has a judgment in the amount that's been pled in the complaint. Obviously, that can be appealed. Also, if a payment on that can be arranged by contacting Mr. Cox's office or filing a motion in court allowing for partial payments or asking for partial payments. So I do wish you well. That is my order. Mr. Cox, you can submit your order to the court, sir. All right, good day to both sides. All right, why are you here, Mr. Proctor?
Good morning, Your Honor. I'm here on the integrated MRI matter. I can give you the case number if you'd like.
I did call that case before. That is case number 21-153-543. That's integrated MRI versus City of Detroit. Your appearance, counsel.
Jason Proctor for defendant, City of Detroit.
All right, thank you. Your P number, if you will, Mr. Proctor.
Yes, 78838.
All right, thank you, counsel.
Good morning, Your Honor. Daniel Groves on behalf of the plaintiff, integrated MRI P number 74026.
All right, thank you, Mr. Groves, and good morning to you as well, sir. All right, so I called this earlier, and it looks like.
Your Honor, if I may interject, I believe Mr. Hamoud is also here on the case.
That's correct.
All right, your appearance, sir.
Good morning, Your Honor. Mohammed Hamoud appearing on behalf of plaintiff, PA 6140.
All right, thank you, gentlemen. All right, so somebody go ahead and update me on what's going on here.
Your Honor, Daniel Groves, and I did say for plaintiff, if I may just make a representation to the court. This case was originally held by my law firm. We represented plaintiff. I was unaware that the substitution went through. And with that substitution, you have another plaintiff's counsel here post substitution. I did file my response, though, so I just wanted to make the court aware. And I believe that defendant filed an objection to my response, which should not have been filed because there was a substitution. So just to be safe, I'm appearing today, but I assert to the court a substitution has been filed, and that I'll leave it to the court's discretion regarding my response filed, but I just did not want to not show up.
Got it. So you filed the response to the city's motion to dismiss, correct, Ms. Groves?
That is correct, Your Honor.
All right. And was there a stipend order for subsequent counsel, or how did that go about, Mr. Mohammed?
Good morning, Your Honor. Yes, I believe it was in July of 2021. There was a substitution of counsel entered and signed with this court.
All right, now it's starting to come together. I wasn't involved in that whole process. So why are you still involved in the matter, Mr. Groves? Well, I see you filed your motion back in 20.
Yes, and I filed a response, and so I don't want to mislead the court, like I filed a response that did not appear today, but there was a substitution and there was confusion, so I mean, I can surely step aside and let Mr. Muhammad take over, but I did file a response, and I just wanted to appear to make the court clear on any questions.
Got it. I do have the response, and it will be up to plaintiff's counsel as to whether or not they would like to rely upon the response that you filed. Given that there's a substitution, Mr. Groves, you're no longer under any obligations with regard to this matter.
Very well. Thank you very much and have a good day.
Thank you. So let's go forward. Maybe Mr. Proctor is in a position to tell me where we are. But go ahead, sir.
Yes, Your Honor. Yeah, there was some confusion. There was a couple of different attorneys kind of doing things. I know Mr. Groves' office appeared on a couple of hearings, but it is AT Law, and Mr. Hammoud, who are counsel of record. And that kind of underlies kind of some of the issues that we've had here, where, you know, we filed discovery in this matter back in the fall, or the late summer fall. It didn't get responded to. We ended up entering a stipulated order. And then Mr. Groves' office actually provided some answers, albeit, you know, quite late, but provided answers. But they were answers provided by an attorney who's not the attorney of record. As we stand here today, on behalf of the city, we filed a motion to dismiss for violation of the court's order on 9/28/2022 to provide full and complete discovery responses. It sounds like we have the attorney issue sorted out where Mr. Hammoud's office is representing this plaintiff. Now, with that said, Your Honor, I don't want to hamstring anyone. I know Mr. Hammoud's office did not file a response. Mr. Groves' office did, to which we filed an objection. You know, ultimately, we just want the discovery information. This case is over one MRI. It's not something that I am trying to hold their feet to the fire on. We just want the discovery. We want the information so we can move forward with the case. So I can give my argument as to the motion, Your Honor, if you'd like, or we can sort out some other deal.
Yeah, Mr. Hammoud, on this point with this discovery stuff, obviously, you were not a part of all of what has gone on here, but that's a pretty serious claim of violation of a specific court order regarding discovery. Go ahead, sir. Mr. Hammoud, it's on you to talk about this. What do we need to do going forward to get this all nailed down? The city has moved to dismiss the matter.
Sure. As Brother Counsel noted, it's a very small bill, which is another issue. But plaintiff's counsel, the original plaintiff's counsel, is the one that answered the discovery answers. I don't see how our discovery answers would be any different from their discovery answers. If there's something Brother Counsel would like something more specific, I can do my best. But we have the same client. It's the same person entering the discovery. So I didn't bother answering any discovery because it seems like Brother Counsel, Mr. Groves, who just took off, answered discovery already. But if there's something that's, like I said, Mr. Proctor is looking for that's more specific, I can do my best and have those, specific answers answered. I just didn't see that I just didn't see why we would need two discoveries initially of the same answers. The only thing that would be different would be at law instead of Mr. Groves in the caption. So it's your discretion, Your Honor.
We're asking the court to allow you to adopt the answers submitted by by prior counsel. And you're willing to supplement those answers to the extent that you have additional information, or that additional information may be available. Is that what you're saying?
Please.
All right, Mr. Proctor, where do you need additional? I don't think under those circumstances I'd be inclined to grant the motion to dismiss in this case. But I will take that under advisement. That'll be hanging out there rather than just.
I think that's an appropriate course of action, Your Honor. We are looking, so prior to filing the motion to dismiss, we did reach out to the counsel, Mr. Grove's office, who provided the answers. So essentially, the two kind of big points in the discovery that were lacking were who they cite a claim reimbursement specialist. So we would need the name and the background information on that person. And then the reasoning and rationale for the CPT code that is used for this for the service that's at issue in the case. So those are the two big things. And then the only other matter pertaining to this discovery is the fact that it was unsigned by the party. So if we can get those kind of two subsets of information, that being the claim reimbursement specialist and the reasoning and rationale for the CPT codes, and then get a signature by integrated, I think that would suffice. If Your Honor would be willing to just kind of hold this under advisement to allow them to supplement, I think we would be okay with that course of action.
Those supplements do not seem to be unreasonable, Counsel. Mr. Ho.
I agree, Judge. I can have them by the end of the week, no later.
So what I'll do is the motion to dismiss be taken under advisement. The court allows the plaintiff office at law, Mr. Ho, to adopt the answers that have been previously submitted by prior counsel, and allows opportunity to supplement those answers, and I'll grant a period of 14 days to supplement the answers based upon the specific requests that have been made on this record of the three items: the signing and reimbursement specialist name, and the coding used. I believe is the second issue. The third issue, of course, is the signing of the document. I'll allow a period of 14 days to complete those items on or before the 28th of February. On or before the 28th of February, the discovery must be supplemented in that way. And then I'll set a new date in this matter. Let's look to the end of March, March 28th, 3/28, 23, and that's going to be at 9:45 a.m. And let's see where the case is at that time. Maybe you've found your way to a resolution. If not, we'll find out. At that time, the court makes some decisions about the direction that the case has to take.
Thank you, Your Honor. Would you like me to submit an order to that effect?
That would be helpful, given that I got a little bit of power going on.
No problem at all.
That really
I'll
would
get
be
that.
helpful.
I'll get that
Right.
submitted today, Your Honor.
All right, thank you. And that's, you can send that to Carmen.Banks, C-R-M-E-N, Carmen.Banks, last name is Banks, at 36districtcourt.org, 36th, 36districtcourt.org.
I will do so, Your Honor. Thank you.
All right, thank you. Thank you, Mr. Mahmood. Good day to you. Good day to you, Mr. Parker.
Good day.
Thank you very much, Your Honor.